Real Estate Exam Questions with Answers and Explanations, Part Number 8. Which of the following types of discrimination was not included in the original Fair Housing Act of 1968? A. Race. B. Religion. C. Sex. D. National origin. Correct answer, C. Sex. The original Fair Housing Act of 1968 prohibited discrimination in housing based on race, color, religion, and national origin. Sex was added as a protected class later, in 1974. For example, a landlord who refuses to rent an apartment to someone because of their gender would be violating today's Fair Housing Act, but this was not illegal under the original 1968 version. This means that gender-based housing discrimination wasn't outlawed until the law was amended in 1974. Which of the following types of discrimination was not included in the original Fair Housing Act of 1968? A. Race. B. Religion. C. National origin. D. Disability. Correct answer, D. Disability. The original Fair Housing Act of 1968 prohibited housing discrimination based on race, color, religion, national origin. Disability, along with familial status, was added later through the Fair Housing Amendments Act of 1988. For example, a landlord refusing to rent to someone because they use a wheelchair became explicitly illegal after 1988, not under the original 1968 law. This means protections for individuals with disabilities were not part of the law until the 1988 amendment. Susan just found out that legal information about her property was published at the county clerk's office a few years ago. Her real estate agent never informed her about the legal status, even though it was public record. Susan had no idea about it and couldn't have known because no one pointed her to the information. Is this legal? A. Yes, because once information is public record, the buyer is responsible for discovering it. B. No, because the agent has a legal obligation to disclose all public records. C. Yes, because the agent didn't know either, and ignorance is a valid excuse. D. No, because the agent should have deleted the public record before closing. Correct answer, A. Yes, because once information is public record, the buyer is responsible for discovering it. Under the principle of constructive notice, once legal documents, such as liens or easements, are filed with the county clerk or recorder's office, buyers are considered legally aware of them, even if no one directly tells them. It is the buyer's responsibility to conduct due diligence, which includes title searches and reviewing public records. For example, if Susan didn't check the county records or have a title company review the legal status, the law assumes she still should have known, because the information was publicly available. This means the agent might have acted unethically but did not necessarily break the law. While researching her property, Susan learns that a neighbor has been openly using part of her land as a driveway for several years. The use was never recorded at the county clerk's office, but Susan saw it herself during multiple visits to the property before purchasing. What type of notice applies in this case? A. No notice, since it wasn't in public records. B. Actual notice, because Susan personally observed the use. C. Constructive notice, because she could have found out if she researched. D. Implied notice, because someone else mentioned it to her. Correct answer, B. Actual notice, because Susan personally observed the use. Actual notice refers to knowledge that a person actually has. In this case, Susan saw the neighbor using the driveway, so she had direct awareness. Constructive notice would apply if the information had been available through public records, regardless of whether she saw it. For example, if Susan saw the neighbor's car using the driveway several times before buying the property, she can't later claim she didn't know, she had actual notice. This means she was directly aware of the condition, even though it wasn't officially documented. Before buying a home, Susan received a title report that showed an old easement recorded in the county clerk's office, allowing the utility company access to part of her backyard. Susan didn't read the report carefully and now wants to block the company from entering. What type of notice did Susan have? A. Actual notice, because someone told her directly. B. No notice, because she didn't understand the report. C. Constructive notice, because the easement was publicly recorded. D. Implied notice, because it wasn't mentioned at closing. Correct answer, C. Constructive notice, because the easement was publicly recorded. Constructive notice means a person is legally considered to know information that is available in public records, even if they didn't read or understand it. In real estate, once a document is recorded, like an easement, the buyer is expected to have been aware of it. For example, even if Susan didn't read the title report carefully, the law assumes she should have known about the easement because it was part of the public record. This means she had constructive notice, even without actual awareness. Deed restrictions for residential properties can be enforced only by the A. Local zoning board. B. City or county government. C. Homeowners or homeowners association. D. Real estate broker. Correct answer, C. Homeowners or homeowners association. Deed restrictions, also known as restrictive covenants, are private agreements that limit the use of a property. They are typically created by developers or homeowners associations and are recorded in the property deed. Enforcement is not the responsibility of government entities but is handled by other homeowners or the homeowners association, HOA, within the development or subdivision. For example, if a deed restriction prohibits building a second story, and a homeowner tries to add one, the HOA or a neighbor could file a legal complaint to stop the construction. This means that private individuals or HOAs can take legal action if someone violates the restrictions written into the deed. A double net lease is a rental agreement where A. The tenant pays only rent while the landlord covers all property expenses. B. The tenant pays rent plus property taxes and insurance. C. The tenant pays rent plus all building expenses, including maintenance and utilities. D. The landlord pays property taxes and insurance, and the tenant pays only maintenance. Correct answer, B. The tenant pays rent plus property taxes and insurance. In a double net lease, NN, the tenant agrees to pay both property taxes and insurance premiums in addition to the base rent. The landlord remains responsible for structural maintenance and repairs. For example, a retail store signs a double net lease and pays $2,000 month in rent, plus $500 month for property taxes and $300 month for insurance. This means the tenant pays more than just rent, covering extra costs related to the property. Which of the following is an example of functional obsolescence in real estate? A. A home located near a busy airport. B. A property with outdated electrical wiring. C. A house that flooded during a recent hurricane. D. A commercial building with a cracked foundation. Correct answer, B. A property with outdated electrical wiring. Functional obsolescence refers to a loss in property value due to outdated or inadequate design, layout, or features, even if the structure is physically sound. Outdated electrical wiring is an internal characteristic that no longer meets modern standards, making it a clear example of functional obsolescence. For example, a 1950s home has knob and tube wiring that cannot support modern appliances. This means the home's internal systems are outdated and reduce its usefulness and market appeal. Which of the following is an example of severance in real estate? A. Turning a garage into a guest bedroom. B. Planting trees in the backyard. C. Removing a ceiling fan and taking it when moving out. D. Installing a new water heater. Correct answer, C. Removing a ceiling fan and taking it when moving out. Severance occurs when an item that was once part of the real property is removed, converting it into personal property. A ceiling fan, once installed, is considered a fixture, real property, but when it's removed, it becomes personal property again, which is severance. For example, the seller uninstalled the ceiling fan from the living room and took it to their new home. This means they removed an attached fixture, turning it back into personal property, an act of severance. An example of depreciation in the cost approach can be found in A. The increase in property taxes due to neighborhood growth. B. The presence of a cracked foundation in the property. C. The recent rise in comparable property sales. D. The demand for properties in a nearby school district. Correct answer, B. The presence of a cracked foundation in the property. In the cost approach to valuation, depreciation means a loss in value. This loss comes from things like wear and tear, outdated features, or outside influences. A cracked foundation is a type of physical deterioration. This kind of damage lowers the value of the building. So, it's a clear example of depreciation under the cost approach. For example, the appraiser deducted $20,000 from the replacement cost of the house due to structural damage, including a cracked foundation. This means the cracked foundation reduced the home's value as part of the depreciation in the cost approach.